IAS Barber 60-Day Rapid Revision, Rare, Series UPSC IAS Prelims 2022. Daily Handouts. Polity. Day 2, Topics. 1. Current status of fundamental rights with respect to DPSBs. 2. Fundamental, constitutional and legal rights. 3. Absolute and non-absolute fundamental rights. 4. Fundamental rights specific to citizens and otherwise. 5. Education, FR, DPSB as well as FD. 6. DPSB and welfare state. 7. Enforceability and justiciability of DPSBs. 8. Writ petitions and principles of locus standi. 9. Personal Data Protection Bill. 10. New IT rules and liberty. 11. Pegasus and privacy. 12. Justiciability of fundamental duties, National Honours Act. 13. Indira Sony case, its recent violations thereof. 14. Shatrughan Chauhan case and right to life. 15. Powers and limitations of state governments to provide reservations. ISBABA's 60 Days Rapid Revision Series, Rare, Notes, Day 2, Polity. 1. Current status of fundamental rights with respect to DPSBs. Case Supreme Court Judgment. Champakam Durarajan v. the State of Madras, 1951. Any conflict between the fundamental rights and the directive principles, the former would prevail. Golaknath v. the State of Punjab, 1967, fundamental rights could not be amended by the Parliament even for implementation of directive principles. It was contradictory to its own judgment in the Shankari Parsad case Kesavananda Bharati v. the State of Kerala, 1973. In this case, the Supreme Court overruled its Golaknath, 1967, verdict and declared that Parliament can amend any part of the Constitution but it cannot alter its basic structure. Minerva Mills v. the Union of India, 1980, Parliament can amend any part of the Constitution but it cannot change the basic structure of the Constitution. 2. Fundamental, constitutional and legal rights. Natural rights, these are universal rights which are inherent in every individual being a part of human nature. They are not conferred by law but only recognized and made enforceable by law. For example, right to life. Human rights are similar to natural rights in the sense that they are universal and are intrinsic in human nature. They are retained by an individual on the basis of his/her being a human. They are contained in United Nations Universal Declaration of Human Rights, 1948. Civil rights, these are the rights that citizens of a country enjoy and are conferred by the Constitution or the law of the country. Civil rights may differ from one country to another while human rights are universally enjoyed by all. Constitutional rights, they are right enshrined in the Constitution. Some enjoy special status as fundamental rights and some other do not enjoy such status, for instance, outside Part 3 of the Indian Constitution, other than fundamental rights. Fundamental rights, they are a branch of civil rights and are given higher importance in India as they are defended by the Supreme Court directly. They are essential for human development, democracy and social progress. 3. Absolute and non-absolute fundamental rights. Absolute rights are those which does not come with any constitutional or legal restrictions. Also, there is no reason to restrict such rights. Example, rights given under Article 17 cannot be restricted under any circumstances. This also holds true with the Article 21A, there is no reason to withhold someone's right to education. Non-absolute right, this comes with the reasonable restrictions. Example, right to freedom of speech is being restricted by the very Constitution. However, right to privacy is restricted by law and Supreme Court judgments from time to time. 4. Fundamental rights specific to citizens and otherwise. F are available only to citizens and not to foreigners. F are available to both citizens and foreigners, except enemy aliens. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, Article 15. Equality of opportunity in matters of public employment, Article 16. Protection of 6 rights, Article 19. Protection of language, script, and culture of minorities, Article 29. Right of minorities to establish and administer educational institutions, Article 30. Equality before law and equal protection of laws, Article 14. Protection in respect of conviction for offences, Article 20. Protection of life and personal liberty, Article 21. Right to elementary education, Article 21A. Protection against arrest and detention in certain cases, Article 22. Prohibition of traffic in human beings and forced labour, Article 23. Prohibition of employment of children in factories etc., Article 24. Freedom of conscience and free profession, practice and propagation of religion, Article 25. Freedom to manage religious affairs, Article 26. Freedom from payment of taxes for promotion of any religion, Article 27. Freedom from attending religious instruction or worship in certain educational institutions, Article 28. 5. Education, FR, DPSP as well as FD. Article 21A. The right to education inserted in Constitution via 86th Amendment Act. Article 45. The state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. Article 51A amended, which made the opportunities for education to child a fundamental duty of the parents of the children. 6. DPSP and welfare state. Part 4 of the Constitution of India, Article 36 to 51, contains the Directive Principles of State Policy, DPSP. DPSP promote the welfare of the community. Hence, they are societal and socialistic. These principles aim at ensuring socio-economic justice to the people and establishing India as a welfare state. The founding fathers of Indian Constitution were aware of the fact that independent Indian state was going to face many challenges like poverty, hunger, and with deep-rooted socio-economic inequalities. The framers of the Constitution felt that certain policy directions, guidelines or instructions for the governance of the country were required to handle these problems. Legislature, executive, and administration of the independent India were expected to exercise their powers in accordance with the direction and guidelines given in this part of the Constitution. 7. Enforceability and justiciability of DPSPs. DPSP consists of all the ideals which the state should follow and keep in mind while formulating policies and enacting laws for the country. These are non-justiciable, that is, they are not legally enforceable by the courts for their violation. The courts cannot declare a law violative of any of the directive principles as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. 8. Writ petitions and principles of locus standi. 5 types of writs which a person can file before a High Court or the Supreme Court under Article 226 and Article 32 respectively. The authority against whom the writ petition is filed has to be present within the territory of India, otherwise, the petition has no value. In law, standing or locus standi is a condition that a party seeking a legal remedy must show they have, by demonstrating to the court, sufficient connection to and harm from the law or action challenged to support that party's participation in the case. Writs meaning provisions habeas corpus to have the body of. This writ is used to enforce the fundamental right of individual liberty against unlawful detention. The Supreme Court or High Court can issue this writ against both private and public authorities. Mandamus we command. This writ is used by the court to order the public official who has failed to perform his duty or refused to do his duty, to resume his work. Mandamus can be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. Prohibition to forbid a court that is higher in position issues a prohibition writ against a court that is lower in position to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. It directs inactivity. Certiorari to be certified or to be informed. This writ is issued by a court higher in authority to a lower court or tribunal ordering them either to transfer a case pending with them to itself or quash their order in a case. It is issued on the grounds of an excess of jurisdiction or lack of jurisdiction or error of law. It not only prevents but also cures for the mistakes in the judiciary. Quo warranto by what authority or warrant. Supreme Court or High Court issue this writ to prevent illegal usurpation of a public office by a person. Through this writ, the court inquires into the legality of a claim of a person to a public office. 9. Personal Data Protection Bill. Personal Data Protection, PDP, Bill, 2019 is the India's first attempt to domestically legislate on the issue of data protection. Bill removes the requirement of data mirroring, in case of personal data. Only individual consent for data transfer abroad is required. Bill requires sensitive personal data to be stored only in India. Bill mandates fiduciaries to provide the government any non-personal data when demanded. Bill also requires social media companies, which are deemed significant data fiduciaries based on factors such as volume and sensitivity of data, to develop their own user verification mechanism. 10. New IT rules and liberty. The Supreme Court, SC, had in 2015 struck down Section 66A of the Information Technology Act, finding it contrary to both Articles 19, Free Speech, and Article 21, Right to Life, of the Constitution. According to the new IT rules of 2021, significant social media intermediaries providing services primarily in the nature of messaging shall enable identification of the first originator of the information. Identification of the first originator will require end-to-end encryption to be broken, thereby compromising the fundamental technology on which most apps are based on. 11. Pegasus and privacy. The SC described privacy and its importance in the landmark decision of K.S. Putterswamy v. Union of India in 2017 as a fundamental and inalienable right. It also said that the right to privacy attaches to the person covering all information about that person and the choices that he/she makes. The right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as a part of the freedoms guaranteed by Part 3 of the Constitution. 12. Justiciability of fundamental duties, National Honours Act. The fundamental duties of citizens were added to the Constitution by the 42nd Amendment in 1976, upon the recommendations of the Swear-and-Sing Committee. Fundamental duties are essentially taken from the Indian tradition, mythology, religions, and practices. Citizens require to observe certain basic norms of democratic conduct and democratic behavior because rights and duties are correlative. Verma Committee on Fundamental Duties of the Citizens, 1999, identified the existence of legal provisions for the implementation of some of the fundamental duties. No person can disrespect the national flag, Constitution of India and the national anthem. Protection of Civil Rights Act, 1955, provided for punishments in case of any offence related to caste and religion. 13. Indira Soni case, its recent violations thereof. Indira Soni and others versus Union of India, 1992, the Supreme Court upheld 27% quota for backward classes, and struck down the 10% government jobs for economically backward classes among the higher castes. Combined reservation beneficiaries should not exceed 50% of India's population. Introduced the concept of creamy layer. Violations of the judgment. Many states have passed laws breaching the limit of 50% such as Maharashtra, Telangana, Tamil Nadu, Haryana, Chhattisgarh, Rajasthan and Madhya Pradesh. Tamil Nadu Reservation Act, 1993 provides 69% reservation in state government jobs and educational institutions. The Maharashtra State Reservation for Socially and Educationally Backward Classes, SEBC, Act of 2018. 14. Shatrughan Chauhan case and right to life. The central government has filed a petition before the Supreme Court, seeking a time limit of 7 days for death row convicts to file a mercy plea. Shatrughan Chauhan vs. the Union of India and others, judgment defined the procedure and guidelines to be adopted in cases of prisoners on death row. The existing guidelines to execute the death penalty are more convict-centric rather than victim-centric. Over the years, it has been observed that convicts of heinous crimes misuse Article 21, right to life, to delay the judicial proceedings and in turn death sentences. 15. Powers and limitations of state governments to provide reservations. Objective of providing reservations to the scheduled castes, SCS, scheduled tribes, SDs, and other backward classes, OBCs, in services is for empowering and ensuring their participation in the decision-making process of the state. The Supreme Court, in Mahesh Kumar and Anna v. The State of Uttarakhand, deals with question of reservations in promotions for disadvantaged groups in public services. The Apex Court opined that reservations for disadvantaged groups were not fundamental rights, and it would be well within the discretion of states' power to reserve or not to reserve seats. The impact of reservations, as an enabling provision of the Constitution of India, has thus been diluted and left at the discretion of the state. Points to be remembered. Fundamental rights in news. Right to reservation is not a FR. No court could ask a state government to provide reservation. Right to protest is FR. Right to protest peacefully without arms is FR under Article 19. 1b. Public spaces cannot be occupied indefinitely by protesters. Right to internet is FR under Article 19 of the Constitution. Article 19. 1g. To practice any profession, or to carry on any occupation, trade or business. Suspension on internet should not be for indefinite period and must follow proportionality test. It was not elevated to the status of a human right. In India, Kerala had become the first state in 2017 to declare access to internet a basic human right. Right to live-in relationships is FR. Supreme Court validated live-in relations, granted individuals freedom to live as they think best. Living together is a right to life, under Article 21. Right to information is FR. Right to know provided under the Right to Information Act 2005, RTI Act, is FR under Article 19 and 21. Rights defined under Article 30 are not absolute. Article 30 doesn't prevent the state from imposing reasonable regulations to make administration of minority institutions transparent. Important amendments to the Constitution. Preamble. It added 3 new words to the preamble. 1. Socialist. 2. Secular. 3. Integrity Fundamental Duties Part 4A was added to the Constitution. Article 51A, Recommendation of the Swear and Sing Committee Directive Principle of State Policy. 4 new directive principles were added. 1. To secure opportunities for healthy development of children. Article 39, 2. Enabling free legal aid. Article 39A, 3. Protection of workers in factories. Article 43A, 4. Protection of environment and to safeguard forest and wildlife. Article 48A. Directive principles were given precedence over fundamental rights, and any law made to this effect by the Parliament was kept beyond the scope of judicial review by the court. Legislature life of Lok Sabha and State Legislative Assembly was extended from 5 to 6 years. Judiciary made the constitutional amendments beyond judicial scrutiny. Curtailed the judicial review power of the High Courts. Insertion of Article 32A in order to deny Supreme Court the power to consider the constitutional validity of a state law. Another new Article 131A gave the Supreme Court an exclusive jurisdiction to determine question relating to the constitutional validity of a central law. Provided for the creation of the All India Judicial Service. Executive Article 74, 1, was added, which made the President bound by the advice of the Cabinet. Gave special discriminatory powers to the Speaker of Lok Sabha and Prime Minister. Article 329A. Federal insertion of Article 257A, to enable the Centre to deploy armed forces to deal with any grave situation of law and order arising in any state. Empowered the Parliament to make laws to deal with anti-national activities, and such laws are to take precedence over fundamental rights. Emergency. It authorized the President to declare emergency in any part of the country. Articles 323A and 323B, Part XIVA added, entitled as tribunals dealing with administrative matters and tribunals for other matters. Subjects to concurrent list transferred. 5 subjects to concurrent list from state list, that is, 1. Education, 2. Forests, 3. Weights and measures, 4. Protection of wild animals and birds, and 5. Administration of justice, constitution and organization of all courts except the Supreme Court and the High Courts.